Itai Fletcher here for +61J. We've just finished court hearing number 74, and these are comments from Manny Wax and the lawyer defending Malka Leifer about what happened in court today.
We've seen 74 charges to date, and from my perspective, the defence team has been exploiting this system, and we must have a review of the Australian judicial process. At the same time, we've also seen repeated victim blaming. As much as Kaufman here wants to stand up and say that they didn't get into victim blaming, absolutely there was victim blaming today and previous times. The fact that there can be a suggestion that any of these girls consented to having some sort of sexual contact with their school principal is absolutely absurd. And that is something that is angering, and I know that when the girls hear this, and I just spoke to one of the complainants, and each and every one of these court hearings is difficult, and each and every one of these court hearings, things come up and re-traumatise, and to have over so many years, so many cases, and so many absurd allegations by Leifer's defence continuously raised in the courtroom is something that to us is unacceptable. Sure, everyone deserves the presumption of innocence, they deserve legal representation, but there are some red lines we do not cross, especially by someone like Kaufman, who claims he was a prosecutor and understands the feelings of victims and survivors of child sexual abuse.
So we've now reached the final stage of the extradition process. We raised a number of arguments. The arguments which were made regarding consent or lack of consent on a factual basis weren't argued in the appeal.
So what was argued? What is your main defence today?
Well, we were arguing on the issue of dual criminality, whether or not the extradition treaty recognises the ability to extradite somebody for an offence of non-consensual rape, when the extradition treaty itself did not include the provision for rape which could be committed by way of digital penetration. It sounds a bit technical, but it's a valid legal argument.
So you were saying then that there was non-consensual action?
Once again, the issue of consent or non-consent was not raised on appeal. That will be decided by the court in Australia if Mrs. Leifer should be extradited.
What's the likeliness that she's going to go to Australia?
What's the likelihood that she's going to be extradited to Australia? I hope that she won't be extradited to Australia. I should add that one of the additional points of appeal that we made were that should she be extradited to Australia, and once again I hope that will not happen, but if she should be extradited to Australia, we're asking for her to serve her sentence here in Israel.
Do you believe there's been political interference from the Australian government in this case?
I'm not going to comment on that because that could form the basis of a future appeal if necessary. I believe that the Minister of Justice has made inappropriate comments, but now is not the time to raise that issue.
What other avenues are there of appeal? Isn't this the last avenue? We've reached the Supreme Court.
This is the last legal avenue. Once we finish this hearing and once a judgment is rendered, then the Minister of Justice himself has to sign off on the extradition order. That extradition order and that decision is subject.
How do you explain this dragging feet, this stalling thing, this case, which drags on for years and years and years? Is it normal or is it just a farce?
Well, you've used the word farce, you've used the word stalling and dragging on over years. But let's not forget that Mrs. Malka Leifer in the first instance was found not competent to stand trial. And as a result of that judicial decision, and not as a result of any, how can I put it, legal ploys on behalf of defence counsel, the proceedings came to a halt for a substantial number of years.